On behalf of the, we're good to record. So on behalf of the Central Pennsylvania LERA Group, we would like to welcome you all to our March meeting, March 1st. We're starting the month off right with a great meeting here. What we would like to do is, as we typically do, is go around and introduce ourselves. First, I'd like to introduce and thank Bernadette, who is our representative here from LERA, the national group. And then what I would like to do is introduce our officers. So on this call, we have Catherine Rowe, and we also have Chris Ruppau, who is our secretary and treasurer and all things local LERA for us. And we have Joe, who is our former president. And what I would like to do is have everyone take an opportunity to go through and introduce themselves. So it may be easier for me to call out the names here. And if I forget someone, we will please forgive me. And then I will wrap back around to Joe when we are finished to introduce our wonderful speaker for today. So the first person, Larry, could you introduce yourself?
Sure, I'm Larry Cheskowitz. I'm an arbitrator and conciliator from around the Allentown area.
Very good. David Breen.
Arbitrator and mediator in the wonderful Steel City of Pittsburgh, Pennsylvania.
Very good. Deb, please go ahead.
I'm Deb Wallet. I used to practice both sides of the labor law spectrum, and now I'm a full-time arbitrator, but sort of semi-retired at the moment. I'm in Mechanicsburg, by the way.
Very good. And Jane Rigler, please.
I'm Jane Rigler. As Mark just said, I work as an arbitrator and mediator, and I live in Carlisle.
Very good. Joe, I'll go back to you to give you another shot there.
Thanks. My name is Joe Canamuccio. I am an attorney for PSEA, the Pennsylvania State Education Association. So the big, we're a teachers and other school employees organization, a labor organization, and I'm in our Harrisburg office.
Very good. Thank you. Kate, I'll go back to you, and it's easier for me just to go down my list. So go ahead.
Thanks, Mark. Hi, everyone. I know most of you, but for those I don't, and for those I'm seeing again, my name is Kate Rowe. I'm a shareholder with Strokoff and Cowden. We do labor side and plaintiff side work primarily. I do have behind me my dog Nova, who is the world's laziest associate, but she's wonderful and I love her. And she oftentimes makes appearances at LERA meetings. We've had them via Zoom. So it's good to see everybody.
You're muted, Mark.
Chris, you can go ahead and introduce yourself. I will let you give your own introduction here.
Now you're muted, Chris.
Go ahead, Chris.
Now am I muted? Chris Ruppno, I live in Lemoyne. I'm retired from PSCA. I was in the research division for 30 years in our headquarters building in Harrisburg.
Very good. Thank you. And Emily, please go ahead.
I think Emily's actually in a different meeting. She just jumped on to make me host. But Emily is our executive director at the National LERA office.
Very good. I remembered her last time. And go ahead. Is that Ezio Porcini?
Hi, everybody. I'm an arbitrator in Bethesda, Maryland.
Okay, if we could have Jay, tell us about yourself.
Good evening, everybody. I represent management, although the managers who I advise would probably argue otherwise. And I'm responsible for the Commonwealth of Pennsylvania's Labor Relations Program and Employee Benefits. And I live in Marysville and work in Harrisburg. So good evening, everybody.
Very good. Good evening. And Gary.
I am a arbitrator and a mediator from Cincinnati, Ohio, where we had the second best team in the Super Bowl. And so I have several cases coming up. Got a line on the, just became a national mediation service. So I can do railroad and airline cases. And so I'm part of the National Mediation Service or Association, I forget. But I don't know how often I get cases. There's a lot of arbitrators there, but anyway, that's about it.
Very good. Thank you. And Jay?
I think you got me a couple minutes ago.
Sorry about that. The names keep jumping up. How about Josh Grubbs, please?
Josh Grubbs. I am a director of labor relations at shoot, now did my video go away? At AppScuff. I work out of Harrisburg.
Very good. Thank you. And Julie Reese?
Hi, I'm Julie Reese. I'm a director of labor relations at AppScuff as well in Harrisburg.
Very good. And then I have Ems Saveda.
I'm Michael Sreda. I work for ASME Council 13. I'm an AGP manager processing grievances statewide.
Very good. I have a name here. Larry, did I get you already? If not, please go ahead.
You got me.
All right. Is there anyone that I missed before we go to the introduction of our speaker this evening? Not hearing anyone. Joe, could I turn it back over to you to introduce our great speaker for this evening?
Absolutely. And thank you. Tonight I have our last introduction. Last but not least, I have the privilege of introducing our presenter for the evening, Jenni Chavis. Attorney Chavis practices in the Harrisburg area as a solo practitioner. Her early legal background is in criminal prosecution, as she worked for a time in the Dauphin County District Attorney's Office. Since then, she's been a prosecutor for the Bureau of Professional and Occupational Affairs, which, relevant to tonight's topic, regulates various licensed professions in the Commonwealth. She was a hearing examiner for the Commonwealth as well. And so it makes sense that her current practice, which I've pulled from her website, so I know it's true, is split about 70-30, it sounds like, between criminal defense and issues relating to professional licensure. Tonight, she'll be discussing something very much in her wheelhouse, maybe a bit outside of the experience that some of us here have, even though I think it comes up all the time in the employment arena, and we thought it would be a good topic to share. She'll be discussing the collateral effects of criminal convictions on licensure, specifically on licensure, and maybe we'll even get into a little bit the effect of these on employment generally. There's some hot topics in here, no doubt. So please join me in thanking Attorney Chavis for speaking with us, and Jenni, take it away.
Good evening, everybody. Thank you so much for having me here, Joe. Thank you so much for that introduction. I am truly hoping that what I share with you this evening will be relevant to your experiences and something that you can take along with you. If not, I hope it's just interesting enough for you to want to just interact. And, I'm going to talk through some things. If you have any questions at the end, please feel free to ask some questions. Joe, I think, is going to be monitoring the chat for me because I have a lot going on here. I'm looking at one screen. I have notes down here, so I don't think I could handle, a third issue. So I just want to start off by letting you know the presentation I want to give you this evening, I did once before, maybe a year or two ago, for criminal defense attorneys. And so it was trying to show them the overlap between licensure issues and their defense in criminal cases. So I picked DUIs because when a person is charged with driving under the influence in Pennsylvania, and they're also a licensed individual, there's a possibility to hit a lot of the different issues. So while I picked DUI, some other charges, some other crimes may also trigger the same type of actions from the board. But if you have any questions specific to an issue, we can certainly talk about those. at the end as well. So I just wanted to kind of preface that in the presentation. So now I'm going to go to sharing my screen. Let's see here. All right. All right, if we can get a thumbs up if you guys can see what I'm sharing. All right, thank you, Mark. I appreciate that. All right, so and let me start with a little bit about who I am. We heard it from Joe, so I'm not going to go over that too much. But the reason that I really love this particular area of law, specifically the professional licensure, and I'm actually hoping to increase that area of my practice. There are not a lot of us who practice in this area, licensure defense. Kate, we were able to talk about this before we started, about how there are really not a lot of attorneys who do it. And I think that there definitely is a need, and I'm going to share about some of that as we go through the presentation. And honestly, it's just this area of law that is this mystery. And even when I talk to licensed individuals and I tell them that I do professional licensure defense, they really have no idea what we're talking about or what I might be talking about. And I felt it was really necessary to, or I wanted to go in an area of law that I felt that there are people who were underrepresented. You have licensees who are going to some of their hearings or facing discipline without even consulting an attorney, and it ends up just a mess for them. And as you can imagine, people who've worked hard to get a license, it will clearly have an impact on their livelihood, on their family lives, things of that nature. So it's so important to make sure that they have the protection that is needed, for their license, something they worked very hard to obtain. So let me just go over a brief overview about the Department of State and who really controls these issues. So within the Commonwealth Department of State, there are many units within the Bureau, or within the Department of State. And one of them is the Bureau of Professional and Occupational Affairs. So we're going to talk a little bit about that. I'm going to tell you a little bit about the disciplinary procedures. And I'll try my best not to get bogged down, especially not as much detail as I gave when I gave it to criminal defense attorneys, but just enough so you can understand what does the process look like. And also just to explain how the disciplinary procedures can impact someone who is licensed and ultimately impact their employment. And the last thing I want to talk to you about is going to be the Professional Health Monitoring Program. And so this is one area of Department of State that is put in place to monitor licensed professionals that could prevent more severe discipline to their licenses. I'll explain a little bit about that in a little bit. So some of you might know our Department of State, like most other Department of States in other states, will usually consist of things regarding elections or corporation bureaus. And here in Pennsylvania, it encompasses charities, but also they also are the branch that oversees the 29 professional licenses within the Commonwealth of Pennsylvania. It does not include educators, it doesn't include attorneys, but I will show you some of the boards that it does oversee. So it covers things such as chiropractic, dentistry, medicine, nurses, physical therapy, podiatry, psychology, social work and social workers, marriage and family therapists, professional counselors. There are a lot. And so they're broken off into two different branches. You have the healthcare related side, like the boards that I just mentioned. And then you have the business related boards, such as funeral directors, accountants, cosmetologists, barbers, real estate agents, geologists, and landscape architects. I never had a landscape architect case, or I don't think I had a geologist board issue, but nevertheless, they are licensed professionals. And so there is some governance over their particular license. All right. So within the Department of State, oh, there we go. So within the Bureau of Professional and Occupational Affairs, we have the boards, prosecution unit, professional compliance office, the Bureau of Enforcement and Investigations, and then, as I mentioned before, professional health monitoring program. So let's break it down. So the boards, they are made up of anywhere from 7 to 17 members. They're going to include professionals in that particular field, as well as public members who represent the public at large. The members are appointed by the governor and they're confirmed by the Senate. And each board has what's called board counsel or Commonwealth attorney, who is hired specifically through the Office of General Counsel, assigned to the Department of State, and they work directly with that, usually one board. They're going to run the board meetings. They will advise the board. They almost sit I don't want to say judge, but they're giving them legal opinion and how hearings should run if a hearing is held in front of the board. They will also write opinions or decisions on behalf of the board. The prosecution unit of BPOA is exactly what it sounds like. Now, while it is not criminal prosecution, they are the branch of BPOA that will initiate the proceedings against the actual license. The board prosecutor or the prosecutor is absolutely separate from board counsel. And there's a case that states that they have to be completely separate, even though they exist in the same building and even on the same floor of the same building. The double doors that separates those units are very distinct to make sure that there's no overlap between what the board is doing and board counsel and then what the prosecution is doing. So our Commonwealth has about 30 attorneys who work in the prosecution unit who initiate and litigate the disciplinary cases on behalf of the Commonwealth. And so they just work very hard to make sure that there's no overlap between them and the board counsel. The professional compliance office or professional compliance officers, they're the intake unit of BPOA. And so, you know, if you were to go on the Department of State website, or if you see anything regarding Department of State and licensure, you'll usually see, like, if you have a complaint, call this number or email a complaint to this email address. They are the unit that actually will take in any complaints, and they will then provide that information to the Bureau of Enforcement and Inspection to then investigate any of those complaints. If additional paperwork is needed, say for a conviction, they are the unit that will then go out and get the certified copies from the court of a person's conviction and provide it to the investigators or to the prosecutors who are handling the case. And lastly, PHMP, they are the branch of Department of State, if you will, that monitors licensees when they're in some type of program, specifically health licensing boards, to ensure that those licensees are safe to practice. We'll get into that in a little bit. So disciplinary procedure. So generally speaking, a disciplinary action against a licensee or against a license, actually, and what do I mean by that? Unlike a criminal case where it is Commonwealth versus John Smith, and it is that defendant who is being charged with the crime. In licensure cases, it is not Dr. Smith or Nurse Jones who is defending him or herself. It is a disciplinary procedure against the license that was issued by the board. And so the person who has that license has a proprietary interest, and they are the ones on behalf of that license who then respond to the discipline that has been initiated by the prosecution. Generally speaking, disciplinary actions are permanent parts of the board record and they are public information. So how does discipline begins? As I mentioned, there are complaints that are received by the compliance office, by PCO. And once the complaint comes in, the disciplinary process will then begin with prosecution, sometimes filing what's called the order to show cause, which will then require the license holder to then respond to it within the prescribed period of time. Now, some information is given to the board by way of what's called JNet, is the Pennsylvania Justice Network, where if someone is dealing with a criminal case or has a criminal conviction, someone within the Bureau of Enforcement and Inspection can then see it. They can see it through the JNet. Oh, John Smith has a DUI conviction. And so they're alerted. That can also initiate a disciplinary process. Also, employers. I met with a client today who was suspected of some misconduct at her job, specifically diverting controlled substances. And so that employer, once that's was suspected, then provided that information to the board, and that then initiated an investigation, and disciplinary procedures have begun for that particular licensee. Every Pennsylvania licensee, no matter what board they are a part of, they have the responsibility to know and to understand and comply with the laws and regulations that govern that practice of their profession in the Commonwealth. A lot of times I meet with clients who will say, well, I didn't know I had to report that within 30 days. I didn't know that I had to change this with the board. Like, just because you didn't know, or perhaps in the minutia of all the laws and regulation, you didn't have all that memorized, there still is an obligation as a license holder to be familiar with all the laws and regulations that will oversee or govern the practice of their profession. And that includes even if there is disciplinary actions in other states. For example, nurses. A lot of times there are nurses who are traveling nurses and are licensed in multiple jurisdictions. They have to then understand, well, what's going on in Missouri and how can any disciplinary action in Missouri impact what's going on with my license in Pennsylvania. So in 2018, approximately, there was a new, more stringent reporting requirement for all BPOA licensees. And this really made it uniform so that for all licensees, they're under this obligation to report all disciplinary actions from other jurisdictions in writing within 30 days. It used to be 90 days. But now, after the passing of this act in 2018, it was 30 days. And they must report in writing if it's a finding or verdict of guilt, if they've admitted guilt, if they're, entered a no contest plea, whatever it is, they have to let the board know, even if it's related to a felony or misdemeanor in a criminal proceeding within 30 days. They provide a website for licensees to do so. And if a licensee fails to make the report, it actually could be the basis for additional discipline. So a failure to disclose. Oh, I didn't realize I had that slide. So that's what it looks like. The reporting requirements under that particular statute there. And there's the citation. For anyone who's interested in, reading a statute tonight, there it is. 63 PS 2202.1. All right, so every person, even though this is a non-criminal case, and I'm not going to go into the weeds on this, it is still, every respondent has the constitutional right to due process, which means it is the right to notice and a right to a fair hearing. So they still have the opportunity to have their day in court. And I mentioned this a little bit at the beginning, that I was really surprised when I worked as a prosecutor for Department of State, and when I was a hearing examiner, at the amount of people who would receive notice of a disciplinary action starting, and they would just never respond to it. They wouldn't call in to find out, well, what is this about? How do I respond to it? They would do absolutely nothing. And then once you have the allegation out there and there's no response, the prosecutor can ask for essentially a default judgment that what was presented in their allegation be deemed as true, be deemed as a fact. And once that happens, it shuts the door on the licensee's ability to, in some instances, go back and be able to contest it. Or there are instances where people would show up and they would just, I think well-intentioned, would just sort of come in and, hey, I want to say my side of the story at a hearing without consulting an attorney or without, without representation. And I applaud them for doing that, because at least showing up, they at least have a fighting chance of the discipline not being so bad, or the outcome not being so bad. But just a failure to respond to the notice as given, it really can just, hamstring someone and really have a huge impact on their license. So that was just the only thing I'll say about due process. Now, the possible disciplinary outcomes, they may include public reprimand, which is, a bad mark on your record. It goes into your permanent file, sort of like a censure. There could be a requirement to attend some type of remedial education or training. Most licensees have required yearly continuing education credits that are needed. So they might tack on additional ones for, or perhaps a skills assessment. There could be a civil penalty, and that could be up to approximately $10,000 per violation. And so if you have someone who is being charged with violating the regs or the statute for their particular license, and they have like 3 charges against them, that's up to $30,000 possibly for the violation if it's deemed true or found true. There could be a suspension of license. Sometimes what the board might do is, they may say, we're going to suspend the license for a year, but we're going to stay a portion of that. So we're only going to have an active suspension for 30 days, and the remaining 11 months will be on probation. And so then what's also there is a possible probationary outcome, revocation of license. And then, of course, disciplines become public information. So all of you, I'm sure you have some type of provider, a doctor or a nurse or something like that. You could go to the Department of State website, put their name in, and find out if they've ever been disciplined. And it's right there. Some of the details will be right there regarding what happened or the outcome of that particular discipline. Let's see. All right. So now this, depending upon how you view it, is either viewed as discipline or perhaps a way to avoid discipline. So the board can, prior to filing, initiating proceeding, the order show cause, depending upon the facts of the case, a prosecutor can petition the board to order that a licensee undergo a mental or physical examination. In order to do so, the prosecutor has to present to what's called a probable cause screening committee, like 3 people of the board. They do a petition, they read it, and determine whether or not the licensee is potentially has an issue with impairment. Then the board, if they agree with the petition that's outlined by the prosecutor, they will then order the person to go to a board-approved evaluator that will give them a mental and physical examination. The evaluator will look at records. They may conduct urine tests. I know one will send in the person to have the hair follicle testing and whatnot. Now, if a licensee refuses to attend, the possible outcome, that's where you get into the disciplinary phase, that they could possibly be suspended. Also, a refusal what might happen is the licensee or what was in the petition might be deemed admitted. Like if you have a licensee who is compelled or requested to go to a mental physical examination and does not respond to it, then whatever facts the prosecutor put in the petition could be deemed admitted. So let's get an example. So if you have someone who is charged with DUI, and also they're a nurse who their employer says she was diverting drugs at work. If that person is asked to go to mental physical examination and they don't do it, then that petition about the DUI and the diversion of drugs can then be deemed true. And then when they go to hearing or determine what is the actual discipline, what is the outcome, they can't go back and say, oh, that employer just doesn't like me and they made that up. They can't go back to necessarily contest those facts. They could be deemed admitted based on just the petition of the prosecutor. All right, so I had one colleague, we were talking about this presentation a couple years when we were putting this together, and I'm not sure where we came up with this or how he got the information, but he was saying that typically DUIs is the most common way to trigger a mental physical examination. Now, it does happen for other reasons. For example, while I was a prosecutor, we had an individual who was a doctor, and he was in some stage of either Alzheimer's or had dementia, something like that. And so there was a concern about his ability to practice safely. So there was a request for him to undergo a mental physical examination. So it's not always impairment. It could be some other issues, but this is just a possible avenue for the board to determine whether or not the licensee is safe to practice. So that's why I started by saying it's not necessarily discipline, but of course, if you receive something in the mail compelling you to go to mental physical examination, then certainly it would feel like that you're being disciplined to a certain degree because you're being told something that you may not necessarily want to do. All right, so I told you that I was going to talk about the Professional Health Monitoring Program, or PHMP. So as a part, their mission statement is protect the citizens of the Commonwealth from unsafe practice by Commonwealth licensed professionals diagnosed with physical or mental impairments. This responsibility is fulfilled through the identification and referral to appropriate treatment of such licensed professionals and the case management and monitoring of their cases for a period of at least 3 years to verify stable recovery. So in Professional Health Monitoring Program, it is the belief that they want to help licensees continue to practice safely. And so let's say if it is, they hear a word about, or hear about a person who has a DUI, then they will then send a letter to the licensee and say, hey, we understand that you have this charge of DUI that is out there. They can offer them this program to be monitored, to fulfill certain conditions, and for it never to become discipline in the sense that it's public knowledge and there will be no restriction at all to their license to practice. And so it's called the Voluntary Recovery Program, VRP. And so a lot of times, licensees will get this letter in the mail, and some of them will wonder, well, I don't want to do this. There's nothing wrong with me. And I'm going to show you some instances why I at least counsel clients to consider VRP because of the potential impact if they don't do it. So this VRP branch of this program, of the monitoring program, like I said, it keeps it from being public information. It keeps it from preventing them from being able to practice. And most oftentimes, that's the biggest issue. People will say, but am I still going to be able to work? Yes, they'll still be able to work, generally speaking. So what usually happens, to be eligible for VRP, the licensee must be a part of a VRP participating board. So remember, we talked about there's 29 different licensing boards. Not all of them necessarily participate in VRP. You have to suffer from a DSMV diagnosis of impairment, such as chemical dependency or mental health disorder. You have to agree to the terms and conditions of VRP, and voluntary sign what's called a consent agreement. Again, this is all about it being voluntary. So some of the VRP licensing boards are going to be chiropractic, dentistry. Let's see, I think I have it here for you. Oh, here they are: medicine, nurse, occupational therapy, all of those boards that are listed there. What will be required while they're in the VRP program? Any recommended treatment, support groups, monitor practice, random drug testing, and of course, not, if it's an issue with controlled substances, not using those controlled substances. It's a provisional enrollment where they will say, do you want to be a part of it? They're going to assess whether or not you're fit to be in the program. And then of course you have to sign the agreement to participate. You have to undergo an evaluation. So you have to pay, it's about $500, at least at the time that I made this slide, it was about $500. And so if after the evaluation, there's a determination that there is no impairment, then the case is going to be closed. If there is some type of impairment, then you have 36 months to be a part of the program. And successful completion, as I said, there's no discipline on the record, and then it's not reported to the National Practitioners Data Bank. Why is that a big deal? Because if you have licensees who are billing directly to insurance companies, they must have zero restriction on their license. Doctors, dentists, chiropractors. For nurses, it's not that big of a deal because they aren't directly billing. So if you have a person who's a licensee who says, I don't want to go through VRP, and it's determined after the disciplinary process that they still have to be a part of the monitoring program, at that point, it is a public discipline. And the only way to then participate in PHMP is through probation. That means there's a restriction on their license. So that's why I say there are times when I counsel clients, you've been offered VRP, it might be a good idea to do so, because if you go through the disciplinary process and the allegations are found to be true, or you're found to be enough to discipline your license, more often than not, they're going to recommend, the board is going to rather not recommend, require you to go through PHMP. But at that point, it's public, and the only way to do it is on probation. That is going to severely, it makes doctors, dentists, chiropractors, people who do direct billing to insurance companies unemployable. So it has a devastating impact on their career. So that is the things where I was just talking about there about, well, what if it's declined? Then at that point, the Commonwealth or prosecutor's office has the ability to jump in to either compel for the mental physical examination, or, start with the order to show cause and then have a hearing to determine what the outcome will be. It is a roll of the dice, because at the hearing examiner, which is, it's a person delegated to hear the case on behalf of the board, can find that there's no impairment or there's no issue, or can find that there is, and you're just right back in the same boat of having to participate in the monitoring program. Let's see, I'm going to sort of get to the end here. So I'm going to scroll through just a little bit. Oh, that was the end. Okay, so last part of discipline that I want to talk to you about is there are situations where the board can actually do a temporary suspension of one's license, depending upon the board and depending upon the issue. And so by petition without an initial hearing, the prosecutor can go in front of that probable cause screening committee that I mentioned and say, listen, there's something really egregious that's going on. And for this reason, we need to temporarily suspend the person's license so that they're not working until this issue has been resolved. The notice is sent out about this temporary suspension. And so very quickly, within 30 days, the licensee is entitled to a preliminary hearing. And so there's a hearing to determine whether or not the temporary suspension should continue on. And it will continue on either until the board vacates it, but no longer than 180 days. Because at that point, you have a prosecutor going to make a decision about whether or not there's enough to go forward, or if the issue has abated, or the person may decide not to practice anymore, depending on what the issue might be. And so, ladies and gentlemen, that's it. And so I hope that you can see some tie-in with employment or how that could possibly impact you on a day-to-day basis, specifically about the type of discipline. You know, as I mentioned, for some licensees, if there's any restriction at all on their license, from probation, obviously suspension or revocation, that can have devastating impact on their employment and on their careers. If it's something that is not as serious as that, if it is just a civil penalty, or if it is just a, just a public reprimand, then perhaps it's not going to impact them on their jobs. But these licensing issues are certainly ones that should never be ignored. They need to be dealt with promptly. Most of them have time limits where responses have to be filed. And it's always best to go in with some type of representation, or at least consulting with someone, so that way a licensee can go in and, of course, be prepared for whatever might happen and go in with the best shot of being successful. And so that is all that I have. Thank you. And I'm more than happy to take any questions. I know there's a lot of information, but I'm more than happy to take any questions that you might have.
Thank you so much for that presentation. I have been monitoring the chat. I didn't see anything come through, so we'll open it up to questions. And I know I might have one, but I'll leave it to others to jump in if they have any first.
I've got a question. In the proceed, and I hope I'm using the right terminology, in the proceeding before the hearing officer, would you call it what I might call a formal proceeding, like a trial in a court of law, or might it be more slightly informal? And I will use an arbitration, a labor arbitration, as an example. And you know, the rules of evidence apply, and opening statements and cross-examination, all that.
All that applies. And so it really is a hodgepodge. It's not, as I would say, as formal as, say, like a jury trial, but it definitely has the same elements. So, you know, counsel or you know, the parties have the ability to make openings and closings. You know, under the administrative rules, you know, hearing examiners aren't supposed to really, you know, be so strictly in their adherence to the Pennsylvania rules of evidence, but they still might apply. Like it is certainly not a free for all. And then even amongst hearing examiners, it really changes. You know, so you may have some hearing examiners who are very, you know, very relaxed with what is admissible. For some, they might be a little bit more formal. So it really is a hodgepodge. You know, it's just a matter of knowing who you're going in front of, and of course, always just being prepared to make the best presentation, whichever direction it's going to go.
I have a question also. Is there a right of appeal for the practitioner?
Yes. So generally speaking, once you go through, especially when you go through the hearing process and you have that, say, let's go through the process of, it goes in front of a hearing examiner. They've been delegated to be the fact finder and make that initial proposed decision. So the licensee, or even the Commonwealth, honestly, if they disagree with something the hearing examiner has decided or written, they can file an exception to the board. And then when the board is considering the hearing examiner's decision, then they will also take into account the exceptions. Then the board can issue their final determination, the final order, either adopting what the hearing examiner found in totality or a part of it, or, you know, changing some parts of it. And after that final order is then issued, the licensee or the Commonwealth, depending upon just the licensee, can then do the appeal to the Commonwealth Court. I'm just trying to think. I think the Commonwealth might also be able to appeal. I never did it myself. And then as a hearing examiner, once I was done with it, I don't recall if the Commonwealth necessarily did an appeal to Commonwealth Court, but I'm assuming that they can. So the short answer is yes, there's an appeal process.
Okay, thank you.
Mm-hmm.
I'll go ahead with mine. Given what you said about how for probably most, maybe not all, but at least most of the professions, having the license is probably a requirement of your job. If you're a doctor, you need to be a doctor in order to be employed in your current capacity. And that's why the consequences are so direct and devastating, as you said. Given that, what's your experience? How involved are employers in this process? Where do they get involved? Do they intervene? Do you usually see them being witnesses on one side or the other? I'd be very interested to know your experience and how employers get involved in this and where you normally see them in the
Sure.
process.
So that's really interesting. So I've seen fellow employees who have come in and can talk about, who will talk about a licensee, say, work ethic. And it's for the purposes of showing like mitigation, like, okay, maybe they did have an issue with substance abuse, but they're doing great. They're a great worker, reliable, consistent, that type of thing. I don't recall in that context an employer doing it, because I just don't know if there would be an issue of liability if an employer is going to be willing to say, to put themselves on the line for testifying for someone, particularly if it's an issue where it was, like a controlled substance or an impairment issue, and that's why the person is being disciplined. Versus like not getting enough CE credits, so there's discipline and then there's discipline, right? And now there are some instances where there was this one time, I probably will never forget this case. It was for a CNA. And that was through Department of Health. And whenever there's an issue for a CNA, it is swift and it is really, I think, extremely harsh for people who don't get paid a lot, who are working really hard. And so if anything happens to the patient, I mean, it doesn't even rise to, I think, to a level of neglect in this one particular woman. And so her employer actually paid for her attorney's fees, because they knew that if it was found that she was negligent, then she would be suspended for a year, and she wasn't making enough money to not go a year without working. You know what I mean? So it was a really rare instance where this employer really felt for her. She was a great worker and went to bat for her. It is not often, but it does happen from time to time, depending upon the circumstance. But I would say certainly more the exception than the rule.
And I do have one question that came in through the chat. Who is the ultimate finder of fact? The hearing examiner, the board? Is it the same for all boards? Any thoughts there?
So not the same for all boards. Some boards will not delegate to a hearing examiner. I'm trying to think which one. I want to say, I'm not sure it's pharmacists, but there's a couple boards like they will do all their hearings, which means they are the finders of facts. Like that's it. For the ones who do delegate, so the hearing examiner becomes that first line of, well, I don't want to say defense, but that first line of being the finders of facts, because they will then give proposed findings of facts in their proposed adjudication order. And so then the board has the opportunity to review the record, and then of course they can make their own findings, but more often than not, they are going to kind of adopt what the hearing examiner said, because it's not only just reading on a piece of paper, but the fact finder then is also judging credibility, because they're looking at and seeing and hearing the witness. So they do rely upon the hearing examiner to a certain degree, which is why they're willing to delegate it. But the ultimate finder of fact coming to that final order, I would say, would be the board, even if they are relying upon a hearing examiner for that initial proposed findings.
This is Deb. I don't know how to use the chat, so I'll just ask my question. This is directed to some of the other arbitrators. To what extent are the transcripts, for example, from these disciplinary procedures actually admissible at termination hearings before labor arbitrators?
Was that for me, or you said it was for, or was that
for anybody, or any of the arbitrators?
You're asking, Deb, whether somebody who's had her license, been through the disciplinary process with the Department of State, if there's a transcript of that, and at a arbitration, a grievance arbitration, one party or the other wants to introduce the entire transcript, would I admit it? Is that what you're asking?
Or have you had occasions like that?
I haven't had that occasion. I'm always wary. I suspect you've had this, Deb, where somebody wants to introduce evidence of a unemployment compensation determination. And those always make me very nervous. I'm reluctant to include them in my record. But others may feel differently.
It's especially interesting given the amount of formality there seems to be with the disciplinary, because I know you see a lot of the times people say, well, that's less formal, it's quick, it's, in the referee decision type thing. And so, and then the order becomes, I think, important too. But it's an interesting question.
So I have a question here related to any employer responsibilities. Is there a mandatory reporting responsibility of an employer? So it seems that as you were talking, that the actual license holder is responsible to make sure that they report any wrongdoing. Is there an employer responsibility as well?
That is a very good question. And so I am going to have to rely upon my memory for that one, Mark, because I don't recall it being a major issue, but I do recall instances where, and this is especially in dealing with, like when I was talking about the probable cause screening committee, and I would have to do the petitions for whether it's like a mental physical examination or for the temporary suspension. And I recall a lot of information coming from employers. So they were potentially all other licensees. Let's say, for example, nurses. So the director of nursing is a licensee. And so I believe that there is a provision, I think that there is a provision that requires them, if they're seeing something, another licensee doing something that is demonstrates an unsafe practice or that they're potentially a harm to patients, that they must report that. And because by the same token, I know with attorneys, there's an obligation. If there's something that we know is fishy, there's an obligation for us to report that. And so if that's the same if that is what it is for lawyers, and a lot of these disciplinary and professional rules are very, very similar across licensing boards. Even though attorneys aren't under BPOA, the rules are very, very, very similar. So if lawyers have that obligation, I can't imagine that nurses, we actually have lives in your hands, would not have an obligation to have to report certain things. They keep it, I don't recall being specific, like you have to report diversion or you have to report boundary issues, boundary violations. But I think they keep it general enough to say if there's something that demonstrates like an unsafe practice, you gotta speak up, you gotta at least report it.
Very good. I could actually see that our paths could cross, even though I'm in a school district, because as I was thinking, my wheels were spinning. I could perhaps have, as I see both you and Joe on the screen, I could perhaps have an issue with both you and Joe, because we have a few employees in our district that are actually dually certified. Our certified school nurses have a certificate issued by PDE, which would travel through the professional standards and practices side, plus their professional license. Also social workers. Our social workers used to only exist under their social work license, but just within the past 2 years, PDE created and issued a new certificate. So they have to also hold a Department of Ed certificate, school psychologists, things of that nature. So you may have another area there where you may be getting some business.
Understood. Thank you. And that's very true. That's the overlap. And also, again, but even with the education, very similar the way in which the regs and the statute are written. So there is, I don't know who wrote all of them, but it's very, very similar. Well, if there's no other questions, I want to say thank you so much. I'm just honored to be here, and thank you for the opportunity to share this information with you. I hope it's helpful. I probably should have done a slide with my contact information, but there's my name. You can Google me. I'm with Chavis Law Firm. If you ever have any questions or concerns, please feel free to reach out, or for someone that you know that might be having an issue, I certainly would love to be able to be of assistance to them. So Joe, thank you. Thanks for the invite.
Thank you so much for presenting. We'll have, you have a LERA mug with your name on it as soon as as soon as we can get the, you know, and normally, you know, in in-person times, we'd be able to just hand it to you. But thank you so much. I know on behalf of everyone, I can say that. And I guess I'll pass it back to Mark to conclude the meeting.
Very good, Jenny. We would like to thank you, and we would also like to thank everybody who was able to participate in our meeting today. We are looking towards the future, and we are excited about hopefully getting back together in person fairly soon. We do have a meeting scheduled for April. We hope that you may join us for that. I believe that's on April the 5th. And then we typically have our final meeting of the year in May. Hopefully, I know that our April meeting will be virtual. I am hopeful that maybe by May things will open up and people will have a comfort level that may allow us to meet in person. But from Central Pennsylvania LERA, we would like to thank everyone for their participation. Have a great evening, and we hope that you consider joining us next month for our April meeting. Thank you all, and good night.
Thanks, everybody.